Hi, my name's Faye and I'm a building surveyor with Harrison Clarke Chartered Surveyors. Today we're going to be going into a little more detail on the Party Wall Award. Often we get inquiries where a building owner will say, "I need a party wall agreement, can you help?" Firstly, a party wall agreement is technically called an award. An award is a document produced by one party wall surveyor, an agreed surveyor, or two party wall surveyors, one acting for the building owner and one acting for the adjoining owner. The aim of this document is to resolve a dispute that is triggered when an adjoining owner dissents or does not agree to a party wall notice. So you may not need this agreement at all. The first step is issuing a party wall notice. If your neighbour consents or agrees to the notice, you will not need to proceed to an award. If you want to know more about party wall notices, we have a helpful video which can be found on our YouTube channel or website. A party wall award does not need to be in place for both parties to benefit from the rights and protection given by the Act itself. What is necessary for this is the building owner serving a valid notice on an adjoining owner. It is a common misconception that an adjoining owner will only be protected under the Act if they have a party wall award in place. A party wall award is made up of three key parts. Firstly, the award itself, a set of requirements which will govern how the proposed work should proceed. Secondly, a photographic schedule of condition. This will document the condition of the adjoining owner's property and should be supported by text descriptions and photos. And finally, drawings detailing the proposed and relevant notifiable works. An award is commonly based on a standardised document, which is then amended and modified to meet the details of the proposed notifiable works. While there is no prescribed format for an award, you will usually see the following details included within it. It will clearly state the details of the two parties involved. For example, the addresses of the properties, the owners of those properties, and the owner's home addresses. It will also include the details of the surveyors who have produced the award. This could be an agreed surveyor or two surveyors and the third surveyor. If an agreed surveyor has produced the award, there will be no third surveyor. The award may also include other details such as the details of the proposed notifiable works, working hours, whether working at weekends is acceptable, access arrangements, security arrangements, method statements, protection measures for any exposed party walls, a time limit for the building owner to commence the works, and costs and who should pay them and when. To be able to enforce an award, the award will need to be deemed to be valid. A valid award creates legal obligations between the parties. If a party breaches the terms of the award, this will create a legal liability which can form the basis for court action by an aggrieved party. A successful action in the courts would result in a court judgment which could then be enforced against the defaulting party in the normal way. The award is for the benefit of the owners, so in the event of a breach of the award, it is for the owners to take enforcement proceedings. Surveyors will always recommend that their appointing owners obtain legal advice if they intend to enforce any part of the award. The Party Wall etc. Act aims to keep disputes out of the courts. We often find that disputes are often best resolved between the neighbours themselves and that solutions can be achieved without needing legal action. If necessary, your surveyor should also be able to help you with this. Once a party wall award has been served on you, you will have 14 days to appeal the award through the county court. However, we recommend that you proceed with caution and in the first instance speak to your surveyor about your concerns. Thousands of party wall awards are made each year, and only a few hundred awards are appealed, with only a handful of those making it to a final hearing. There are limited published cases, and it can therefore be difficult to decide whether it is appropriate to appeal your award with little to compare it to. If you do try to appeal the award, you face huge litigation and cost risk. Appealing an award is classed as contentious litigation, meaning that one party will win and one party will lose, and it is often the unsuccessful party which will have to pay the associated costs. These costs can run into the tens of thousands of pounds, and you may not end up with the result you wish. Appeals can also take many months to get to the final hearing, meaning that your neighbour may have already completed the works. You should not take an appeal lightly. If you really are concerned about the contents of the award, you should seek sound legal advice before taking action. Often, the party wall surveyors may be able to help you resolve the issue without appealing the award, so the first step is always to approach your surveyor. We understand that this brief video will almost certainly not answer all your questions about party wall awards. However, our experienced team of party wall surveyors will be more than happy to chat with you about your concerns and answer any questions you may have. They can be contacted on 023 8155 0051.